Hello, Carolina Law. That's right, we're back here in Chapel Hill for the 8th annual IJ UNC FedSoc SCOTUS term preview. I'm so happy to say that we're back here for the 8th year in a row, like I just mentioned. And this event is up to 6 law schools that we now hold this event at top law schools around the nation. But UNC was the first. This is the granddaddy of them all as far as this event is concerned. So this is always the one that we record for our short circuit podcast. And I'm joined by 2 distinguished panelists today. First, as always, going back to year one of the panelists is Professor Andy Hessick. Professor Hessick went to Yale Law School. He clerked for Judge Raji on the Second Circuit, Judge Randolph on the DC Circuit. He's also an associate dean here at UNC. He's done all sorts of impressive things before coming to UNC and as a professor and associate dean here at UNC. But mostly what I want to talk about is UNC's Supreme Court program, including the tremendous victory you all had last term and my skill in predicting that victory. So Professor Hessick, can you talk a little bit about the program and how smart I am?
Yeah, thanks, Justin. Thanks for having me on again. The Supreme Court program is a clinic-like program at UNC where students work with me and my co-director of the program on cases before the U.S. Supreme Court. We seek out cases, we file petitions, we file briefs in opposition, and then we pursue merits cases if we're so lucky to get a petition granted. And last term, we had a petition granted in the McElrath case, which was a double jeopardy case. And a student found that case. The students wrote the petition. Students wrote the merits brief. And then my colleague argued the case, and we won 9-0.
Congratulations.
Thank you.
Great job. I mean, that's something that I'm sure the students will never forget.
It was fantastic.
Absolutely.
Yeah, I'm sure that's true.
Well, welcome, and I'm sure you'll do as well in the trivia as you always do as the defending reigning champion. Ben, my colleague, Ben Field, you have your work cut out for you, but I should give you a proper introduction. You also went to Yale Law School. You clerked for Judge O'Scanlan on the 9th Circuit, Judge Jordan on the 3rd Circuit. But I think what's really cool about your experience at IJ, Ben, is you've litigated in every one of IJ's pillars, right? And so whether it's free speech, economic liberty, educational choice, property rights, or our project on immunity and accountability, if IJ has that type of case, Ben has won that type of case. And so, Ben, I want to ask you, do you think the breadth of your litigation experience will give you an advantage during Supreme Court term trivia?
Absolutely. Though I do have my one educational choice case, I did lose unanimously at the Kentucky Supreme Court.
All right, so I don't think there are any trivia questions about ed choice, but good to know. I appreciate your honesty. And by the way, before we get to the event itself, I do want to tell you a little bit about IJ, where Ben and I both work. The Institute for Justice is the national law firm for liberty. We're the nation's largest philosophically libertarian, so just small libertarian, public interest law firm. And so I do mean we're just philosophically libertarian. We sue Republicans as often as Democrats. We don't care about the political affiliation of our clients at all. Ben and I are among the lawyers, the small number of lawyers in the legal profession who have the rare luxury of being allowed to operate solely out of principle. And so what we basically do is we go around the country providing free representation to people whose constitutional rights have been violated, usually to get judges to throw out unconstitutional laws. It's a lot of fun, and IJ really has become quite large. We're up to over 160 employees spread out across our 6 offices. Our headquarters are in Arlington, Virginia. We also have, obviously, an office in Miami, where I am, as well as Austin, Phoenix, Seattle, and our clinic at the University of Chicago. And one reason why we've become so large is because IJ has had a tremendous amount of success. We've had 12 U.S. Supreme Court cases, and we've won 10 of them, including 2 last term. And so, not only do we win these Supreme Court cases, we win really cool cases like this, even cooler than most Supreme Court cases, the cases that you study in law school. So, for example, if you've studied eminent domain abuse, you probably studied the notorious eminent domain case, Kelo versus New London, with Suzette Kelo's Little Pink House. That was an IJ case. Unfortunately, it's one of the 2 we lost, but it was an IJ case. Or if you studied the Dormant Commerce Clause, you probably studied the Granholm direct wine shipment case, or maybe Tennessee Wine and Spirits. Those were both IJ cases. Or if you studied the Eighth Amendment, you probably studied Timms versus Indiana, which is when the Supreme Court incorporated the excessive fines clause. That was an IJ case. And so I got to tell you, it's so cool when, some random lawyer friend or relative will come up to me and tell me about an interesting case they were reading about. And I'm like, yeah, that's my case. Or that's my colleague's Ben's case. And so if you want to have that feeling like we do, you're in luck because IJ has all sorts of openings available, including for summer clerks. Our summer clerk program is called the Dave Kennedy Fellows Program. It is a paid program. Although we're a nonprofit, we're very well funded. And so we pay our summer clerks. And you get to spend a whole summer working on actual IJ cases, actual constitutional cases with constitutional lawyers. If you speak to anyone who's gone through the program, they will rave about it because it really is as cool as it sounds. If you can't wait till next summer to spend more time with IJ lawyers, we also have one-day seminars on a Saturday every now and then. They're called our legal intensives. Where you basically spend a whole day learning from IJ lawyers how to win a rational basis case, which is something your professor might tell you can't be done. We do it. And so the next one of those is at Pepperdine Law School in November in Malibu. And we also have one in January at IJ's headquarters in Arlington, Virginia. And IJ will pay your travel expenses to travel to these events to learn how to win constitutional cases. And if you're a 3L, don't worry, we have programs for you as well. We're constantly expanding, which means we do have attorney positions available. We also have 2-year postgraduate litigation fellowships. And if you're planning to do judicial clerkships and you have a gap year, either a gap year before your clerkship starts or maybe a gap year between 2 clerkships, we have something called the Bingham Fellowships, which is specifically designed to fill that gap year with constitutional litigation at IJ. If you have any questions about any of these programs, go on IJ's website. It's very easy to remember. It's ij.org, and there's info about all of them on there. So please go on ij.org and learn about these great opportunities, and you can come and sue the government like we do. Now, with that being said, let's turn to the actual event today. For those of you who have attended in the past, you probably remember, we'll start with some Supreme Court term trivia to break the ice. After that, both Professor Hessick and Ben will present a case from this docket that they would like to talk more about. Then they will each present a pending cert petition. And then after that, I'll make sure to reserve time for my favorite part, which is audience Q&A. So as everyone's talking, if you have any questions, please kind of store them in the back of your brain and be ready to ask them at the end during the Q&A section. So now, with that said, are you guys ready for some trivia?
Absolutely.
Yeah.
All right, fantastic. So as the audience can see, I have a clear Ziploc bag here with the trivia questions. So we have literal transparency. We'll do 3 rounds of trivia, and I actually have a tiebreaker question this time if there's a tie, as has happened sometimes in the past. Now, Professor Hessick, I think you've won every single year, unless I'm mistaken.
That's not possible.
Well, I think it's not only possible but true. So as the reigning champion, I'll let you pick. Would you rather go first or second?
I will go second.
Okay, so Ben, that means you're up first.
That's my strategy.
All right, Ben, are you ready?
I am.
I believe you. Here we go. All right, Ben. Feliciano versus Department of Transportation asks whether a federal civilian called to active duty during a national emergency is still entitled to increased pay, even if the duty is not actually connected to the national emergency. Here's my question. To which country was Mr. Feliciano deployed?
I don't know. This could be old or it could be new. I'm going to say Syria.
Syria is not correct. Professor Hessick, you want to steal this one?
Sure, Iraq.
Unfortunately, you're both wrong. It was somewhat of a trick question. The answer was the United States. He was deployed to Charleston, South Carolina.
Excellent.
Now, Professor Hessick, you were kind of the closest to having the right answer because he was activated during Operation Iraqi Freedom, but he wasn't sent to Iraq. He was sent to Charleston, which is not a bad place to end up. And so the question becomes, though, even though he was deployed to Charleston, South Carolina, does he still get the increased pay because he was activated during wartime? And so we'll see what the Supreme Court has to say. So, wow, guys, after all that
Solid
hype,
start.
you're not really off to a great
Well,
start.
people do refer to Charleston as the Basra of South Carolina.
Speaking as someone who's been to Charleston, I don't think that's true.
They do now. That's what
They do now, exactly,
Right.
exactly. All right, so no point for the first question. Let's see if the next one's any better. By the way, I'm so happy because there have been years where every question has been answered correctly, and I have vowed to make them a little trickier, and it looks like I'm succeeding.
start.
So kudos to me. All right, Professor, are you ready to take the lead?
Ready to go.
Let's go. Here we go. This question is about Williams versus Washington.
Yep.
Ever since a famous U.S. Supreme Court case over 40 years ago named Patsy versus Board of Regents, challengers bringing Section 1983 claims have not typically been required to exhaust administrative remedies. But the Alabama Supreme Court said that Patsy did not apply in this case. Why not?
Because it doesn't apply to these employment claims.
Ooh, you're gonna have to be more specific. That's close, but it's not really the right answer. I'll give you one more crack at it.
Because it was limited to the particular type of claim in Patsy, and it didn't apply to this type of claim, which happened to involve.
I'm going to cut you off because
All right.
unfortunately that's not going
All right.
down the right path.
Okay.
Thanks for trying.
Yep.
Ben, can you steal the point?
Yes, I can. It's because they argued that it does not apply in state court because that would be commandeering the state court.
That is correct. That is correct. Now, so Ben, you get the point. Well done. And honestly, as someone who brings 1983 claims, it makes no sense to me, right? I mean, whether you're bringing the claim in federal court or state court, if it's a 1983 claim, you should be entitled to fees. And there are really important reasons why you should be entitled to fees if you prevail. And so I'm going to make one of my famous predictions that the Alabama Supreme Court is going to get reversed. But we'll see. We'll see if I'm right as usual.
I thought you were going to say that Ben is going to win trivia.
Oh, I'm not. Dude, I could be mistaken, Professor, but I really think you've either won or tied to win every time. But yeah, Ben's making a run at it. Here we go, Ben. Round 2. Are you ready?
Yes.
Wait, because Professor, you went second, right? Yes.
I went second.
Okay, here we go. All right, Ben. Let's see if you can build on your lead. My next question is on Garland versus Vanderstock, which is the huge battle between federal law enforcement agencies and the makers and buyers of gun parts kits. The government argues that the gun kits are too similar to actual guns and to certain actual gun parts, and therefore make it too easy for people to build their own guns that don't have serial numbers on them, which are otherwise known as ghost guns. But here's my question. This case presents 2 questions to the Supreme Court. Of these 2 QPs, how many are based on the Second Amendment?
0.
0 is correct. Ben, you are on fire. Yeah, and so, as this case gets argued, you're undoubtedly going to see a bunch of media coverage talking about gun rights and the Second Amendment and things like that. This case is not about any of them. It's about statutory construction. It's about whether these gun parts kits meet the statutory definition of a gun or of a firearm, and it's about whether these gun part kits meet the definitions for certain parts of guns, so that the statute also defines certain parts of guns. And that's it. It's just about statutory construction, but because it has to do with a statute about guns, I'm sure the media attention will be understated, as always. So we'll see. But you all will know better. All right, Ben, you have now gone up to a 2-0 lead, but Professor, you haven't had your second question yet, so let's see if you can start to chip away at it. Here we go, Professor. Prosecutors seem to love charging people with mail fraud and wire fraud. Every now and then, the Supreme Court reins them back in, only for the feds to find another rationale for their view that almost every crime also constitutes mail and wire fraud. The latest example is in Cousisis versus United States, and here's my question. In this case, what was the underlying allegedly fraudulent scheme that supposedly resulted in mail and wire fraud?
It was that the Cousisis said that they would use a disadvantaged business, and they didn't end up using a disadvantaged business.
Yeah, that's exactly correct. They actually used kind of a middleman who was historically disadvantaged, who then used other subcontractors who weren't to kind of do an end run around the system. That's not a good thing to do. Like, they should not have done that. But then it comes back to this issue of, well, if that's also mail and wire fraud, then what misdeed isn't mail and wire fraud? And so, since I'm in the predicting mood, I'll say that the court is going to say that's not mail or wire fraud. But we'll see. I'm not 100% sure on that one. So well done, Professor. You've cut the lead in half with only 1 round to go. The score is Ben 2, Professor Hessick 1, which means, Ben, you can clinch it right here.
Yes, but if I get it wrong, then he can get 2 points in this round.
This one is not over. I'd love to use my tiebreaker question. And I want to point out for the audience, if I don't need to use my tiebreaker question, then at the very end of this event, after audience Q&A, I'll ask it to the crowd if you'd like to hear it. Here we go, Ben, for the win. Ben, this question is about a little-known case that might receive some attention named United States versus Crometti. That was a joke, by the way. This is the one about Tennessee law that bans puberty blockers from being given to minors seeking what is known as gender-affirming care, even if their parents want their kids to receive the treatments. After the lawsuit was filed, the United States intervened as a party to help challenge the law alongside the people who were originally challenging it, which is why the case is now named United States versus Crometti. The United States was able to do this because of 42 U.S. Code 2000H-2, but in reality, what was it about this case? What is the criteria in that law that allowed the Attorney General to have the United States intervene?
It allows the United States to enforce constitutional rights.
That is not correct. Professor, can you steal the point?
As I remember it, I think the government said that the government can intervene in equal protection claim that involves a question of important public interest.
Yeah, that is correct. That is correct. It allows the United States to intervene if the Attorney General decides it's an equal protection claim of general public importance. That is definitely close enough to what you said. You get the point, which means we are now tied, right? Yeah, we're tied with one question to go. Professor, are you ready to win again?
I feel like Seabiscuit. Yeah.
Here we go. Here we go, Professor. So if you get this point, you win.
All right.
If you don't and Ben steals it, he wins. If you both get it wrong, we'll bring out the tiebreaker question. Here you go, Professor. In Lackey versus Stinney, the challenger brought a successful Section 1983 challenge against a Virginia law that required driver's licenses to be suspended because of certain types of unpaid debts. The challenger obtained an injunction, and as a direct result of the injunction, the law was repealed. But the government contends that the challenger should not be awarded fees because the challenger did not do what?
Didn't prevail in a relevant sense, and so they are not entitled to fees under 1988.
Can you be a little bit more specific? How did they not prevail? What didn't they get?
They didn't get a permanent injunction. They got a preliminary injunction.
That is correct. That is absolutely correct. Yeah, so Professor wins again. Yeah, and I can tell you, as someone who brings 1983 cases and sometimes gets temporary injunctions, like if you get a preliminary injunction and it leads to the law being repealed, you got everything you wanted. You got everything you wanted. That is a win, exactly. And so the government's position, I think, is a little bit ridiculous. I'm hoping the court agrees with me. I'm not sure. We'll see. But you both did great. You really did. The Professor, you won again, but Ben, you did quite well also. So one more round of applause for the panelists, please. Great job, both of you. Now you're each going to present a case that's already on the docket for this term. Who would like to go first?
Okay.
Go ahead, Ben.
So we're going to talk about Free Speech Coalition versus Paxton. This is a case about pornography. The Free Speech Coalition is actually the clever name for the trade association that represents adult businesses. And so if you're following the news, you probably know that a bunch of states have passed laws to try to prevent children from getting access to online pornography. And this one involves Texas's law, which says if a website has more than a third of its content, it would be obscene as to minors, then the entire website has to do age verification. So they either have to check a government ID or they have to use a reasonable, commercially available age verification system for everybody, which means that it's sweeping in both adults and children. And it doesn't draw a distinction. So like something could be obscene as to a 5-year-old, then that's going to obviously be very different from someone who's something that's obscene as to a 17-year-old, but the law sweeps in all of it. And so the Free Speech Coalition, which, as I said, is the trade group for adult websites and adult businesses generally, brought a challenge to this. And they were successful in the district court. But then the Fifth Circuit, in a split decision, the majority said, we should actually analogize this to a case from the 60s called Ginsburg, which was a guy who sold a girly magazine to a 17-year-old or 16-year-old. And I don't use girly because I'm old-fashioned. That's what Justice Brennan referred to the magazines as, in his opinion. And what the court said, it's fine for New York to criminalize that because it's not limiting adult access. The state can have different standards for children versus adults, and it's okay to define obscenity differently, so that's fine. And the Fifth Circuit said, well, this case is exactly like that, just a digital version of it, and so we're going to uphold it. But Judge Higginbotham, in his dissent, said, well, you're kind of missing sort of the intervening 50 years of Supreme Court case law. And so there was a quartet of cases from the late 80s to the early 2000s, which, in Judge Higginbotham's view, are directly on point. So starting with a case called Sable Communications versus FCC. This now sounds kind of quaint, but apparently there was a product in the 80s called Dial-A-Porn, where you could call a number and you would get pornographic voices on the other side. The federal government banned that, and the Supreme Court said that ban is unconstitutional because it's restricting adult access to this material. In 1997, we had Reno versus ACLU, which was essentially the Communications Decency Act of 1996, essentially banned all indecent online materials that could be sent to under 18-year-olds. And the Supreme Court said that is just way too capacious. That's unconstitutional. In 2000, there was a case for United States versus Playboy Entertainment, which involved a federal law that required essentially adult pornography channels to scramble their signal or to only broadcast between 10 p.m. and 6 a.m. And the Supreme Court said, no, that's, again, you're burdening adult speech too much, and struck it down. And then in 2004, there was Ashcroft versus ACLU, which is in many respects exactly like the Texas law at issue. So it struck down the act called COPA, the Children Online Protection Act, which was a federal law. And it was essentially the exact same definition of indecency and obscenity as the Texas law at issue here. The only difference is that age verification was an affirmative defense rather than a mandate. And that was struck down 5-4 by the Supreme Court. In all of these cases, the court applied strict scrutiny, which means that the government had to show that it had a compelling interest. Pretty much everybody has always conceded that protecting kids from indecent material satisfies that. I'm not sure that every human being would, but the industry has never challenged that. And so it's always been about tailoring. And the court has consistently in all these cases said, no, there are alternatives. And specifically in the Ashcroft case saying, promoting things like filtering software so that the user and their parents are the ones who are filtering, that's a better alternative. And so, but the majority found ways to distinguish all of these. And then the Free Speech Coalition successfully sought certiorari. So that case will be up at the Supreme Court, and it will not only decide, and it's on the formal question of whether strict scrutiny applies or rational basis applies. So that's the narrow question. So conceivably, it'll be decided without actually deciding whether the Texas law is constitutional or unconstitutional. But it'll sort of be the big test case for how this applies. So IJ actually filed an amicus brief in this case where we sort of take the position that the parties have been missing like one of the key issues here.
That happens.
Yes. And our point is that like this law is actually quite distinct from Ginsburg and quite distinct from a lot of these laws in that it's directly burdening speech based on its content. And so it says if you are a website and you have speech of a particular content, you need to take this burdensome action of doing age verification. And our basic point is that the Supreme Court in the 80s had this case called Ward versus Rock against racism, which had to do with noise amplification. It was a very standard traditional time, place, and manner restriction. But there was sort of this throwaway line in it that said, well, strict scrutiny doesn't apply if the government can justify its regulation without respect to the content involved. And courts sort of ran with that since then in saying, well, as long as there's some content-neutral justification, that doesn't matter if the law is content-based in its operation. In the last several years, the Supreme Court has really gone back on that and said, no, if you look at the face of the statute and it's content-based, then strict scrutiny should apply. And our basic point is this statute says if you have this type of content on your website, then you have to do these things. Therefore, it's content-based. Therefore, strict scrutiny should apply, which is different from Ginsburg, where the New York law at issue didn't place any direct requirements on the business. It just said it's illegal to sell to a minor. And that might also have First Amendment implications. If the government is doing something that incidentally burdens speech in that way, it might have a First Amendment implication. But our basic point is this law just directly burdens speech based on content. Therefore, strict scrutiny applies. But I think that what will be interesting to see is that, the court has really changed since 2004. And that was a 5-4 decision with sort of an unusual lineup in that Ashcroft case. So the majority was Kennedy, sort of a free speech, strong absolutist kind of guy, with Stevens, Souter, Thomas, and Ginsburg. So obviously Thomas is the only one left from that majority. There was a 3-justice dissent written by Justice Breyer with Rehnquist and O'Connor, which was a very Breyerian, I agree strict scrutiny applies, but I trust that Congress made the right balance here, and sort of this technocratic view that it's fine what they did. And then Justice Scalia wrote a sole dissent. He's the only one who agreed with the Fifth Circuit's position, which is that rational basis applies. And he didn't even use this Ginsburg analogy. He just essentially said smut is not protected by the First Amendment, and therefore it doesn't apply. So it'll be interesting to see, through the tour of this case law, you've sort of seen that there's in each generation, there's a fun new moral panic about whatever the issue is. And it'll be interesting to see if the court has shifted in the last 20 years on kids and pornography.
Yeah, and I completely agree. And it's also a very useful pro tip for any practitioners out there listening. There are so many groups that they'll file amicus briefs that basically don't add any value. They just say, we just agree with this group or the other group. And frankly, in that situation, no one even reads the brief. They're just filing a brief to say they filed a brief or something. If you actually want to file an amicus brief that gets read and that will actually help the court the way an amicus brief is supposed to, find an issue that the two sides aren't adequately briefing and brief that. That will actually help them out. Sometimes you could even end up getting oral argument time if the justices find your brief helpful enough. So just remember out there, don't file an amicus brief just to say you agree with what's already been said. Find a different angle to actually add value to the proceedings. And with that being said, Professor, what case would you like to talk about?
Thanks. I'm going to talk about Hewitt versus the United States. And it's a statutory interpretation case. So it comes out of some convictions for bank robbery. So in 2009, several people were convicted of bank robbery, conspiracy to commit bank robbery, and other separate offenses. And they had their sentences enhanced because they used a firearm in the commission of these offenses. Now, using a firearm in the commission of an offense, of one of these offenses, it carries a mandatory minimum of 5 years. But the thing is that if you, at least at the time under the law in 2009, if you have multiple crimes for which you are convicted that trigger this provision, then the first enhancement is 5 years, but subsequent enhancements are 25 years, right? Now, this can all happen out of one occurrence that constitutes multiple crimes. So you commit the bank robbery and the conspiracy to commit bank robbery and the other offenses that all happen at the same time, and they can each trigger that enhancement. So that one event resulted in the defendants receiving the 25-year enhancement. And this practice is called stacking, right? So you can stack up the charges that all happened at once. Okay, so they got very heavy sentences. So 10 years later, these defendants, they filed a petition for a writ of habeas, or it was a 2255 action, but essentially habeas. And they got some of their firearms convictions, or some of these convictions overturned, and consequently, removed the sentencing enhancement for those convictions. The habeas court, it also it just decided to vacate their sentences in full and said you need to go back and you need to be resentenced based on the charges that are left, and then sentence can be imposed, and they can look at whatever enhancements apply. But here's the thing: in the interim, right? So after their conviction, but before their successful collateral attack, Congress enacted the First Step Act. And one of the things that the First Step Act does is it eliminates this practice of stacking. You can't do the 25-year enhancement for crimes that happen at the same time, the 25-year enhancement now applies only if you have a prior conviction that carried the enhancement, the 5-year enhancement. Right? So under this regime, the defendants, they wouldn't be subject to the 25-year enhancement. They'd only be subject to the 5-year enhancement. So that makes a really big difference to them. But the Act says, here's what the Act says as a quote. It says, this new provision that eliminates stacking, it shall apply to any offense that was committed before the enactment of this Act. Okay, so that includes the Defendants Act here. But it's only if the sentence for the offense hasn't been imposed as of the date of enactment. And so the Act, it's enacted in 2018, 2019, but the sentence wasn't vacated until later. So this raises the question. The defendants, they were convicted before, they committed the offense before the Act went into place, and they were sentenced beforehand. However, their sentence was then vacated, and they're being resentenced. And does the vacature of the sentence and then the resentencing, does this mean sentence hasn't yet been imposed because the sentence has been vacated? And that's the statutory interpretation issue. The Fifth Circuit said the Act did not apply, that the longer sentence applied, that the sentence had been imposed beforehand, the vacature didn't reset the clock, essentially. And now it's before the Supreme Court. And what's interesting about this case, why I picked this case, is the government, it actually agrees with the defendant. It says that, yes, the vacature, it treats the earlier judgment, the earlier sentencing as if it's not occurred, and so the First Step Act should apply. And the court, it's had to appoint an amicus to defend the judgment, right? So that happens sometimes when the two sides align, when they get before the Supreme Court will appoint someone else as an amicus to defend the judgment below. Typically, it's a former clerk, and that's exactly what's happened in this case. And so it should be interesting to see what happens, whether the government can prevail, or prevail on a position, right, where it's saying, court, please don't do this. And the court might be like, no, government, you have the power to do this, even though you're saying that, you're disclaiming that position.
Yeah, it is interesting. And for me, I just always think about the abuse that we see with stacking, where prosecutors will often take like one misdeed, but then anything you do these days will violate so many different laws. And instead of just having that one punishment, they can throw the book at you and then really coerce these ridiculous plea deals because you just do the math and say, well, I can plead guilty and go to jail for a little time. Or if I don't plead guilty because they've charged me with 20 different crimes for this one offense, I can spend the whole rest of my life in jail. And that's how you end up with people who are completely innocent pleading guilty. And it's a problem. And I'm glad that the Congress is at least trying to rein it in a little bit.
Yeah.
Yeah, but I think that one interesting thing about the First Step Act. So right after it was passed, I was practicing in D.C. at a firm that had a Supreme Court practice that did the thing that everybody does, which is like troll for circuit splits. And like the First Step Act just immediately spawned a bajillion circuit splits on a ton of different questions, because there's always these questions of like, how does retroactivity work? And Congress was less than perfectly clear. Right. But like, it's interesting. So I think that the principal sponsors were Chuck Grassley and Cory Booker. And they have like had this roadshow of filing briefs in all these cases trying to say, actually, we did mean to be very lenient. But it's like quite frustrating because, back in the good old days, like if the courts interpreted the law in a way that Congress didn't like, they would, amend the law to make clear what their purpose was. But, obviously in the years since the First Step Act, criminal justice has become this hot button issue. And it's inconceivable that Congress will actually pass a law to say what they meant. And so we're stuck in this world with everybody agrees is vague language. And it would be best if Congress would actually pass a law to say what it meant. But sadly, they don't do that anymore.
Well, then the court will just say rule of lenity, right? And it's vague language.
I'm a big fan of the rule of lenity, so I guess that's not the end of the world. But now let's talk about cert petitions. Hopefully most of you realize that cert petitions tend to be long shots. At one point, the stats said that only 1% of cert petitions got granted. Even if you took out all the pro se cert petitions and just looked at the ones filed by lawyers, it was only 2%. And frankly, that number has gone down because the court keeps taking fewer and fewer cases. It's not that the cases aren't out there. We could do a whole different session on why the court isn't taking cases, but the cases exist. They're just not taking them. And so these cert petitions are real long shots. That said, though, there are certain criteria that the court looks at and certain things that make some cert petitions more interesting than others. And so the panelists now are going to talk about 2 cert petitions that they think are particularly noteworthy. Ben, which petition do you want to discuss?
Sure. So I'm going to talk about a pair which are closely linked. These are both IJ cases. So it's 360 Virtual Drone Services versus Ritter and Crown Home versus Moore. And I'm going to focus more on 360 Virtual in part because it arises out of North Carolina. And so it is a case where the company that we represent, 360 Virtual Drone Services, basically started by a client of ours who he got into drones, like when drones were a new thing. And he realized like he could provide commercially valuable services. And so, take pictures of work sites so that people can have them and, put things like a scale on them so that people can, get a rough sense of what the distances on the pictures are. And so his business consists entirely of taking pictures and giving them to people. So communicating information. But North Carolina said that is the act of surveying. And therefore, he needs to be a licensed surveyor and to spend like 10 years under the supervision of a licensed surveyor. As we point out, many great Americans like George Washington and Abraham Lincoln were surveyors, and they didn't need a license to do that. Surveying is
Were they accurate surveyors? Do you know?
I mean, I would think so.
No idea.
Obviously, they went on to bigger and better things, so maybe not. But they didn't seem to harm anybody. And so basically, our basic point is this is communicating information. And therefore, he should be protected by the First Amendment. And to just step back a little bit, there used to be, arising out of a case from the 80s, there was one justice concurrence in that case. It had to do with securities advice, which had this idea that, if people are in a professional context and they're giving one-on-one advice, then that's not real speech and therefore shouldn't be protected. And the circuit courts kind of ran with that for decades and allowed licensing all sorts of things, down to our favorite example is this case out of the Fourth Circuit, out of North Carolina, I believe, involving licensing fortune tellers. And the Fourth Circuit said, yep, totally fine. But that all sort of came to a halt a few years ago in this case called NIFLA, which was a case to do with crisis pregnancy centers in California. California was making them make disclosures about abortion that was fundamentally opposed to what they believed in, and it went up to the Supreme Court. And California's lead argument was, they're providing professional services, therefore it's professional speech, and so the First Amendment doesn't really apply. And the Supreme Court said, absolutely not. There's no professional speech exception to the First Amendment. Speech is speech. Go back down and do it again. And so we at IJ have thought that's pretty straightforward. And therefore, if you are speaking, that is speech and should be protected by the free speech clause of the First Amendment. But the courts have been all over the place. So just in surveying, we have these 2 cases, the one out of the Fourth Circuit and the Ninth Circuit, which have said, nope, we're going back to professional speech. We can restrict it without treating it as speech. The Fifth Circuit has done the exact opposite in a surveying case out of Mississippi and said, no, it gets regular First Amendment scrutiny. And not only do the Fourth and Ninth Circuits disagree with the Fifth Circuit, they also disagree with each other. So the Ninth Circuit's version was essentially, we're just going back to old professional speech. In fact, relying on one of the cases that the Supreme Court expressly abrogated in the NIFLA case, saying, no, we're just going to recharacterize this communication as conduct, therefore it's not speech, and therefore it doesn't get any protection. The Fourth Circuit version, I think, is frankly, we've been bringing these cases in a lot of different professions. So death doulas who help people prepare for the end of life and talk to them about making an end of life plan. I've represented them in California and Indiana. We've represented tour guides. We've represented a lot of people who speak for a living, people who teach horseshoeing. And the courts have come out all different ways on those cases. But this one out of the Fourth Circuit is frankly the most bonkers yet, I think, where the court not only said, we're going to treat it as conduct, but we're not going to come up with some crisp line. We're going to create a non-exhaustive multi-factor test to decide whether something is speech or conduct. And some of those things are, so for instance, one of them is the speech happening in public or in private? Which one do you think is more speechy and more conducty? So you might think like, oh, like a private conversation in a church confessional, that sounds like really speechy, right? Well, the Fourth Circuit disagrees with you and says that if it's on a public sidewalk, it's more speechy and therefore gets more protection. They also look at things like, does it have to do with health or other economic consequences? I mean, pretty much any speech, I think you could say fits into that. And certainly the speech in NIFLA did. So it's unclear where they come up with that. And so they've got this non-exhaustive multi-factor test, which I think, we'll see. As I've said, the courts have been all over the place on this. There's a split within the specific question of surveying. And I think this Fourth Circuit case hopefully will be attractive to the court because the court has been trying to take free speech law and draw some brighter lines. And the court generally hates multi-factor tests now. They're much more formalist. And so I hope that the Fourth Circuit has actually, despite ruling against our client, has actually done us a favor by showing just how crazy this area of law has gotten. And hopefully the Supreme Court will agree and take it.
And it has gotten crazy. I mean, just the logic makes no sense. Could you imagine the court ever saying that the New York Times isn't protected by the First Amendment because someone pays to read their articles? The First Amendment doesn't stop applying just because money's involved. But unfortunately, that's how some courts view the professional speech doctrine. And so hopefully the court will fix that. Professor, which cert petition would you like to discuss?
Yeah, thanks. So ordinarily I like to advertise, showcase things that the Supreme Court program is doing, but we only have briefs in opposition in right now, so that doesn't seem like a good idea. So instead I'm going to talk about Henning versus Snowden, and this involves Bivens actions. So for those who don't know, Bivens actions, these are damages actions against federal officials for violating constitutional rights. Now, these Bivens actions, they are judge-made. For when it comes to state actions against state officials who violate the Constitution, there's a statute, there's a federal statute, 42 U.S.C. 1983, that authorizes individuals to bring actions against state officials for violations of their constitutional rights. There's no analog for federal officials. However, in 1971, the Supreme Court in a case, Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, they recognized an implied action. So Bivens involved a claim for damages against federal agents who allegedly violated the Fourth Amendment, stemming from a warrantless search of a house and then using unreasonable force against the plaintiff. So after they recognized that action, the Supreme Court, it extended the Bivens rationale to some other context, for example, the Eighth Amendment. And over the years, courts recognized more and more of these Bivens actions. Fast forward, the Supreme Court, just a few years ago, it said enough with Bivens actions. They no longer support this idea of Bivens actions. And the theory now is, look, it's Congress, not the courts, that has the prerogative whether to recognize damages actions. Congress, if it wants to, it can write a federal statute that's akin to 1983 and authorize damage actions against the federal officials. And the courts shouldn't be in the business of creating these damages actions, right? They should leave it to Congress. And the court has even gone so far to say that if Bivens were decided today, it would probably come out differently, right? So they're not excited about Bivens. But the court has not yet overturned Bivens. Instead, what it said is that it won't extend Bivens. It won't extend it to new contexts. So one of the first things a court has to do now when faced with a Bivens claim is it has to ask, well, is this a new kind of Bivens claim? Meaning, is it new and different in a meaningful way? Because if it's not, if it's the same as the old Bivens action, one that's been recognized before, the courts can go ahead and just apply that law and recognize the action. It's just they're not going to extend it to new circumstances. So the question here in this petition basically is, well, what constitutes a meaningfully new kind of circumstance? And the court didn't really precisely define it, but it seems to be something like if the facts of this new case are different in a way that sort of result in a different policy balancing of whether you would recognize that action, that seems to be a new context for Bivens action, and the courts shouldn't recognize it. But the point is that the inquiry is really fact-dependent, right? Really fact-specific. And here are the facts in this case. So the plaintiff, Snowden, he claims that he was staying at a hotel. He received a call from the front desk, and the front desk said, hey, come on down to the lobby so you can pay for your room. He goes down to the lobby. In the lobby is an agent who's waiting for him. The agent has a warrant, and then allegedly the agent just pushes Snowden down and then starts punching him. Right? Now, if this is all true, that seems like a Fourth Amendment violation. You're probably not allowed to do that. And the question is this similar enough to Bivens? And in some ways, right, it seems pretty similar. So both involved the Fourth Amendment, both involved unreasonable force, both involved sort of similarly situated federal agents. But there are some differences. So Bivens was in the home. This was in a hotel. Bivens, the officer, didn't have a warrant. It was warrantless. And here, the officer did have a warrant. Right? So there's some little differences. Now, the Seventh Circuit, they thought that this didn't matter. They thought that these were sort of not, it wasn't meaningfully new context, and so it said Bivens' action would be recognized. But I think that the court, even though it's not it hasn't overturned Bivens, it has been hostile to any extension of Bivens. So I think that these differences here could really matter. One could imagine Congress saying, like, oh, we'll recognize this action if someone intrudes on your home, but we're not going to recognize it in the context of a hotel. And certainly you could imagine the Congress saying, like, we'll recognize damages actions if there's no warrant, but if you've gotten a warrant, you've been protected, like, we're not going to recognize this damage. Even if you went further and did things that you're not supposed to do, the fact that you got a warrant is some sort of insulation against damages. So I think that as much as any petition before the court, I think this one has a decent chance of being granted because it provides an opportunity for the court to cut back on Bivens further.
Thank you very much. All right, so now we have time for my favorite part, which is the Q&A. And I should say, after we take a few questions, I'll ask the crowd the tiebreaker trivia question that I did not need to ask the panelists. But before we get to the trivia question, what questions do you all have? Just raise your hand and I will call on you. Anyone with a question? None? No? Yes, ma'am. And Professor, would you mind restating the question in the microphone?
Of course. Yeah. So the question is why in the Hewitt case where the government agrees with the defendant's position, why doesn't it render the case moot? And the reason is that the sentence is still being imposed of 25 years, right? If the government could somehow remove that 25-year sentence, then it could be moot. But since he still has a 25-year, that's a consequence of the judgment, and the government can't remove it. There's still a live controversy because the court could decide differently and that 25 years would go away. But it is a real question because mootness, like one reason for the mootness doctrine is you don't want to hear cases when there isn't sort of advocates on either side. And it is a problem when both sides agree, but it's more prudential instead of constitutional.
Absolutely. Any other questions? Yes, sir.
Yeah, I have a spear.
Anyone want to take that one?
I mean, so the question is it becoming more common for the government to essentially flip once it gets to the Supreme Court and for the parties to be aligned? So, I mean, I don't have I can't tell you what what happened in the 70s, but at least over the last several years, between the Obama and Biden administration with Trump in between, I think it's I haven't seen it increasing or decreasing. It just sometimes happens. Either there will be a change in administration, and so the position of the government will change. That can obviously happen in states as well. I mean, I think that it has certainly become, at least people have expressed more concern that the government does not there's become a practice of the government, of the Attorney General and the Solicitor General of the United States not defending laws that they don't like as vigorously. But I'm not sure if that's changed much in the last 10 years.
Yeah, I tend to agree with you. I don't think my sense is it hasn't changed that much. You occasionally see these orders appointing amicus to defend a judgment. You occasionally see the government confessing error, and it happens over time. And maybe it happens in batches more or less now and then, but right now I don't feel like there's a higher frequency.
Right. The one thing that I found galling about the case that you were discussing, the Hewitt case, is that the government opposed certiorari.
Yeah, I know.
Despite
I
agreeing
know.
with the defendant in the lower courts. And as you'll probably know, the Supreme Court docket is not exactly brimming with cases. So I'm not sure why the Solicitor General's office feels the need to be particularly hesitant to acquiesce in cert. And I think, and their basic argument came down to like, oh, it isn't that important.
That's exactly
but this is like the difference between like a 120-year sentence for somebody and a 20-year sentence for potentially hundreds, if not thousands, of defendants. And this is going to keep happening. So I found that to be, I was very disappointed to read that from the government.
Totally agree.
Great point. Any other questions anyone would like to ask? All right, hearing none. Let's ask this trivia question. The way it'll work is I'll ask the question, and here it is. If you think you want to guess, just raise your hand. I'll call on you. We'll see who guesses it correctly first. So panelists, you guys are done. Let's see how smart this Carolina Law School crowd is. Here you go, audience. This question is about Velasquez versus Garland. When non-citizens lose their immigration proceedings, some of them are forcibly deported, but others who are found to be of good moral character can instead be given 60 days to leave the country. And if they file a post-decision motion before the 60 days are up, that time can be extended. In Mr. Velasquez's case, the 60-day deadline fell on a Saturday. His attorney submitted the motion to the Board of Immigration Appeals that Friday, but the board did not accept it as filed until that Monday. The government has taken the position that this means that he has missed the 60-day deadline. Here's my question for this very smart Carolina Law School audience. If the government is correct that he missed the deadline, how long will Mr. Velasquez be required to stay outside of the United States before he is allowed to return? Anyone want to guess? Yes, sir.
10 years.
That is exactly right. Well, now, did you know that, or was that just a guess?
I know the statute.
Oh, you know the statute. Well done. Yeah, 10 years. Really, really. What is your
This is an
name?
impressive crew.
Connor, man, that was impressive. I did not think you'd get on the first. Can we get a round of applause for Connor?
Amazing.
Yeah, and then, going back to the case, this individual, he's lived in the United States for 20 years. He's married with kids. His kids have been born in the United States. He has founded and run a very successful business in the United States. But if he loses this case, he's going to have to stay away from the United States for a full decade, which doesn't sound right to me, but maybe that's just my opinion. And so with that being said, well done, Connor, and thank you all for having us. This was a lot of fun. One more round of applause for the panelists, please. All right. Thank you, Carolina Law. This has been another episode of the Short Circuit Podcast.